for the construction and development of Kimwarel Multipurpose Dam project contrary to Section 103 of the Public Procurement and Asset Disposal Act number 33 of 2015, thereby causing Government of Kenya to suffer a loss of euros 42,088,195.65 to underwriter of the cess insurance. Accused 1, 2, 3, 4, 5.
Kimwarel Multipurpose Dam, a project you knew was not approved and in respect of which you failed to comply with Section 3 as read with Section 78 of the Public-Private
As read with Section 48 of the Anti-Corruption and Economic Crimes Act number 3 of 2003. On or about the 18th April 2017, within the Republic of Kenya, being the Cabinet Secretary, National Treasury, used your office to improperly confer contractual rights and benefits to CMC Diravena Itinera joint venture against the Government of Kenya by unlawfully executing a facilities agreement for the sum of euro 258,666,881.72, being the total contractual sum for the construction and development of Kimwarel Multipurpose Dam. What do you say? Of 2003. Now, this is against accused 1 to 4. That is Henry Kiplagat Rotich, David Kipchumba Kimosop, Kennedy Nyakundi Nyachiro, and Jackson Njau Kinyanjui. Now listen carefully. Between 17th December 2014 and 31st January 2019, within the Republic of Kenya, being the Cabinet Secretary, National Treasury, the Managing Director, Kerio Valley Development Authority, Chief Economist and Head of Europe 2 Division and Director, Resource Mobilization Department of National Treasury, respectively, being persons whose functions concern management of public funds, willfully failed to comply with Section 103 of the Public Procurement and Asset Disposal Act number 33 of 2015 by directly procuring the loan facilities from the financiers, namely BNP Paribas Fortis SA/NV, Intensa San Paulo SPA, Unicredit SPA, and Unicredit Bank AG for the development of Kimwarel Multipurpose Dam. Accused 1. To all parties in advance, simultaneously with a list of chronology of witnesses. In case of a need for production of documents held by the adverse party, this one is in the Evidence Act, but I've seen it misapplied. Such party who seeks such production to issue a notice to produce as provided for under the Evidence Act and file such notice 3 days before the trial. Parties to rely on soft copies. Now this is where I said I've taken care of that. Parties to rely on soft copies unless for a specific reason stated and allowed by the court to be supplied with physical copies, and such application be made on any other date other than the date for trial. I think that satisfies everything. Then parties will agree on a hearing date I just want to clarify that as a party provides chronology of witnesses, the same party should also indicate the documents to be relied on in case they are public documents, and this provision to be read in tandem with provision number 10. What have I left out? Proceed on day-to-day basis. The matter will be given dates on cluster basis, considering that the court has several other matters in order for the protection of the rights of parties in the other matters. This one I've taken into consideration the amount of time it will take, because if we take 3 months, then we'll be trampling on the rights of the others. No adjournment will be allowed unless caused by situations beyond the control of the parties. All applications to be made shall be made and heard, shall be made, decided and heard on other dates not being the hearing dates, not being on the hearing dates. This will not affect applications during the trial on the admissibility of evidence. On representation, neither counsel will be allowed to withdraw representation nor accused to withdraw instructions on the hearing day. In such a scenario, the matter shall proceed, such actions notwithstanding. Yeah? Let us not quarrel on that. Each accused is required to have in his or her possession all the disclosed materials. I believe all the accused are listening. The other issues that come out of that, I didn't want to delve into that, but please do. Plea bargaining is encouraged, but it will not be allowed to interfere with the hearing. In such a case, the parties will only be required to inform the court, and the court will wait for a plea bargaining agreement to be filed for its consideration before judgment. Chronology of calling witnesses to be supplied 7 days in advance, and any such change to be communicated to the other party 3 days before the hearing. Any party needing to use any electronic gadget to make such a request 14 days in advance of the trial to enable necessary arrangements to be put in place. In case of a need of an interpreter, parties to make such requests 7 days in advance of the trial. Considering the voluminous nature of documents, parties are encouraged to make their objections in advance of the trial, i.e., in order to save time in identifying and locating the documents. Such documents should be communicated to all parties in advance. There will not be dealing with admission, but just identifying the documents. Mr. Katwa, you are not. Yes, we are not communicating.
I was just wondering whether you could give us a time indicator around it.
And 31st January 2019, with others not reported, when we conspired to withdraw the government of Kenya.
The particulars are very clear, as the same are tied to the count of willful failure to comply with applicable laws relating to procurement, willful failure to comply with applicable laws relating to procurement, contrary to section 45 2B, as read with section 48 of the Anti-Corruption and Economic Crimes Act. In the particulars,
As read with section 48 of our sector, yeah?
yes,
Yes.
in the particulars, we indicate the law in which he failed to comply with, which is section 68 1B, as read with section 68 2A of the Public Finance Management Act number 18 of 2012.
Yes. And then, after that,
So to us the particulars are very clear because that is the specific applicable law. That is the specific law that he failed to comply with as is required under section 55 of a
you are
sector.
saying we fail
To comply with section 68 1B as read with section 68 2A.
we'll deal with it when we get there. Count 3 will be also against accused 1 to 4. This is willful failure. Assuming insurance by agreeing and promising to pay an insurance to the sum of euro of 2,088,198.65 on top of stamp. And this cost is also. Count 7 is also against one that led to the Corruption and Economic Crimes Act of 2003. The fact between the Queen's April 2017 Finance Management Act number 8 of 2012, the District of the Construction and Development of Kimwarel and Procedural Dam. Before we ask the Finance Management Act number 8 of 2012, the District of the Construction and Development of Kimwarel and Procedural Dam. Before we ask the What next? Now the scenario has changed. You have deconstructed the whole thing. You have demolished your house and constructed smaller houses.
In regard to this particular matter, the evidence remains the same. We shall not be introducing new documents. Neither shall we be introducing new witnesses. Currently, there are 2 active cases, that is SCC 20 and 18 of 2019. Your Honor, we had indicated that we have no intention whatsoever to consolidate.
You said SCC 20 and?
There is SCC 18 and 20 are the most active of 2019. Yes, are the most active cases, and we have no intention to have them consolidated. As much as they may share some accused persons, majority of the accused persons are different in the 2 cases. It would be in the best interest that both cases proceed. As they will cover on different facts.
We have other cases we are doing. So when you have got 7 box files, you don't know which document to deal with. And they say you won't read everything.
Everything.
So yeah, so it's important that they tell us exactly, we'll be relying on this box file, on this document, so that you prepare.
No, I want Madam Tuguri.
You can't just live in the jungle. I mean,
Yes.
yeah.
I want Madam Tuguri.
School plans, the big catalogs of I have almost 100 of them. I need to know which box file am I looking at for which week. It's important, it's proper, so that we have yeah, the next time we come here, we won't even have space. Otherwise we'll come with pickups.
No, I'll take care of that.
The document. So
that one.
yeah, then we for orderliness and good management. I leave that to you, my lord. Yeah, it's important.